A very good evening to you, ladies and gentlemen. I am happy to welcome you to the fifth webinar of Series 7 on professional, personal, and career development titled Navigating Your Career in the Courtroom. This is the 54th BSL webinar for the years 2025-2026. This webinar is organized by the BSL Women Lawyers Professional and Career Development Committee with the BSL Webinars and Legal Symposiums Committee. I would like to take this opportunity to thank the chairperson of the Women Lawyers Professional and Career Development Committee, Ms. Indika Nagaratna, and the co-chairperson, Ms. Nalini Manatunga, conveners, co-conveners, and members of the committee, as well as the chairman of the Webinars and Legal Symposiums Committee and the president of BSL, Mr. Rajiv Amarasuriya, the co-chairman, conveners, co-conveners, and the members of the committee. I would also like to extend my heartfelt gratitude to the Executive Committee of the BSL for all the support and guidance. For today's webinar of Navigating Your Career in the Courtroom, we have with us two esteemed panelists. Firstly, we have with us Dr. K. Kanagiswaran, President's Counsel. Dr. Kanagiswaran holds a Bachelor of Laws from University of London and a Doctor of Laws honoris causa. He is a barrister at law of the Lincoln's Inn and was a member of the team that drafted the Arbitration Act No. 11 of 1995. Dr. Kanagiswaran served as the chairman of the Advisory Commission on Company Law and the Intellectual Property Law, which drafted the Companies Act No. 7 of 2007 and the Intellectual Property Act No. 36 of 2003. He is a leading practitioner in constitutional law, commercial law, intellectual property law, banking law, maritime law, and international commercial arbitration, and has also co-authored a book on company law of Sri Lanka. He was a founding director of the Institute for the Development of Commercial Law and Practice, Sri Lanka, which has the objectives of developing all areas of commercial law in the country and set up the first institutional arbitration center in Sri Lanka in 1996. Dr. Kanagiswaran is also a lecturer at Faculty of Law, University of Colombo, and a visiting lecturer at the Sri Lanka Law College. He has been a member of the Council of the University of Colombo since 2004, having been appointed by the University Grants Commission. I warmly welcome Dr. K. Kanagiswaran, President's Counsel, for today's session. We also have with us another esteemed panelist, Ms. Farzana Jamil, President's Counsel. Ms. Jamil is the holder of an LLB from University of Colombo, LLM in Constitutional and Administrative Law from University of Colombo, and LLM from UCL. She is a legal counsel with over 3 decades of litigation experience and a demonstrated history of working for the state, being the former Senior Additional Solicitor General at the Attorney General's Department. She has demonstrated litigation experience in tax law, customs law, excise law, international trade law, administrative law, international environmental law, and international law of natural resources. I also warmly welcome Ms. Farzana Jamil, President's Counsel, for today's session. To moderate today's session, we have with us Ms. Daphne Perez Visundara, Senior Attorney at Law. Ms. Perez Visundara obtained her Bachelor of Laws degree from the University of Colombo and thereafter took oaths as an Attorney at Law of the Supreme Court of Sri Lanka in 1988. She also obtained her Master of Law degree from University of Colombo. She is the Senior Partner at D&D Law Chambers with practice areas of litigation and dispute resolution, competition and antitrust, notary, construction, testamentary, tax, foreign investment, family law, and real estate. I warmly welcome Ms. Daphne Perez Visundara, Senior Attorney at Law, for today's session. Before moving on with our program for the day, I would like to remind our participants that they can post their questions in the Q&A box, which can be referred to our panelists by our moderator in the question and answer session at the later part of this session. So without any further ado, I invite Ms. Daphne Perez Visundara to commence today's proceedings. Over to you, madam.
Good evening, ladies and gentlemen. At the outset, I wish to express my gratitude to the Bar Association of Sri Lanka for organizing this insightful series of webinars on topics of immense value to both juniors and senior practitioners alike. Today's discussion brings together two eminent figures in the legal fraternity. Dr. Kanagiswaran, President's Counsel, representing the unofficial bar, a true pioneer in the legal advocacy, and Mrs. Farzana Jamil, President's Counsel, a distinguished leader from the official bar, known for her unwavering courage in the courtroom. So I think that the selection is very, very correct in selecting these two panelists. And to begin with, I would like to, as a starting point, it would be fascinating for our audience, especially the young practitioners, to learn what initially inspired you to pursue law. What, when here, I would like you to elaborate on what persuaded you to join the legal profession, and could you share insights about your educational background and your experiences as a student at law school? I asked these questions from our panelists, and I would like to give you about 5 minutes each for these answers.
You want me to go first, is it?
Yes, first to you, sir.
Well, there's a long answer and a short answer. The short answer is I did not select law to be my career. So it selected itself. It happens that my father was the leading advocate in the northern province, but he never wanted me to do law. I was myself interested in science. So I was destined to be, I wanted to be a doctor, not a lawyer. So the short story is, then when I went abroad, UK, for further studies, there came to pass an event which I will call something like the current Argalia in which I was involved, which pushed me into the arms of the law. And there I made a decision, I will switch to law and join the Lincoln's Inn and the University of London to do the LLB. So that is how I came to do law by chance, not by choice. I still would like to have been a doctor. Anyway, that's the short answer to your question. The long answer will take over 1.5 hours. Why it came to pass so?
And over to you, Mrs. Jamil.
Uh, Good evening to everybody here. Hello, sir, and Daphne and Isuri and Miss Indika Nagaratna and Nalini Manatunga. I would first like to clarify one thing. Daphne, you said that there's Mr. Kanageshwaran from the private bar and me depicting the official bar. Just to clarify that, I no longer depict the official bar. I finished that 3 years ago. Way behind Mr. Kanageshwaran in the private bar, of course. So, yes, I did spend more than half of my life there, but I cannot claim to be the person depicting the official bar, just to get that out of the way. As to why I came to study law, totally by accident. My father was a lawyer and his uncles were lawyers, so I am really a third generation lawyer. But law was not what I initially wanted to do. I always wanted to study English literature and become a diplomat. Or on the other extreme, I wanted to study architecture for some odd reason. So when I passed my A-levels and I had to fill up my university application form, I had put English, architecture, and law as the last thing. But my teacher at school got me to change that, amend it, and said, look, child, there's nothing but law for you. You must go first for law. And so I applied and I got into the faculty of law, not by my first choice. I mean, I would have loved to study literature and go in that line, but I studied law quite out of accident. And my parents had nothing to do with my having to turn to law. So that is the background to it. I grew up in a legal atmosphere, seeing clients come to visit my father and see my father. And all of that I was used to, but yet I was not keen to study. It came by accident. But now I don't think I could have fitted in any other place other than this. And you slowly learn to adjust. And actually going into the courtroom was not what I thought I could ever do. I didn't think that I could be a courtroom lawyer. It just kind of evolved into that. Thank you.
Yeah, even although by accident, I think both of you have been brought into this noble profession and you have been very successful in that. And as a next question, I would like to pose to Dr. Kanageshwaran in under this navigating your career in the courtroom. Now, we know many young lawyers often struggle with developing client relationships and establishing their practice. I would like you to uh, speak, sir, on how did you build enduring relationships with clients and what key strategies or principles guided you in developing a sustainable and reputable practice.
Oh,
You can have about 10 minutes on that.
yes. Now I must thank you, Daphne, because I've been now will be very soon about 6 years at the bar. So my story goes back a long way back. And the young lawyer may not know the legal profession had two major periods. There was what I call before Felix and after Felix. Before Felix was 1974, when we did not have a tribe of lawyers called attorneys at law. We had advocates and proctors. The bar was not fused. So advocates and proctors, the role of an advocate and proctor were very different. So the advocate is the one who will deliver in court, argue cases. The proctor doesn't. So we get instructions as to what case to argue in court or what your particular case is on instruction from the proctor. It is the proctor who deals with the clients. Advocates and barristers do not deal with the client. But then in the client relationship, even then we have the relationship, is that one of confidentiality. So anything that is disclosed to you as a lawyer in the exercise of your function as a lawyer is confidential. One of the codes of etiquette of conduct at the bar, confidentiality. So I must say, when we were advocates, when I was an advocate, we never met the client directly. They always will come with the proctors. So the traditional proctors will prepare a brief. They will meet the clients, prepare what they have to say, and then give us a brief, which says what their case is all about. So sometimes they bring the clients and we have a discussion. So there was no direct counsel-client relationship. Once fusion became fused, all became attorneys. Now you could that while the obligation of confidentiality remained, you could meet directly with the client. Traditionally barristers and advocates do not meet clients. See, that was a hangover from the British tradition. So after 1974, when we have the administrative and justice law with the Second Republic, the bar was fused. We had before that advocates and proctors. Now we have bars in Sri Lanka with attorneys at law. So as I say, the attorneys at law were neither fish nor fowl. So you are not trained to be an advocate. You just got through your law exams and you have to decide for yourself which direction you want to go. Now, if you have access to court those days, the access to court was mostly the advocate. Proctors hardly ever appeared in court arguing cases. This was way back before 74. So the confidentiality with the clients remains even to this day. Then building up a good practice. Well, if you are, now with the new lot, it's difficult. There are so many lawyers are passing out. In our time, and I say in our time, there was about 8 years I was advocate before the Republican Constitution came and they fused the profession. And during that time, we had opportunities which we were able to grasp to be able to appear on your own. You see, the first thing is people must notice you. They must see who you are, why you are functioning in court and things like that. So what we used to do was, we used to go, especially those days, criminal trials, assizes presided by commissioners of the Assise, later judges of the Supreme Court, where they give doc brief, but they call, now they call it assigned counsel brief, I believe. Free brief, or you are given 31 rupees 50 cents for a to do a case. There you have the chance, because if you are not known and fresh, nobody will brief you, nobody will trust you with the brief. So you need to show that you are able to conduct a case in your own right. So you showcase yourself. Those days, which we did, was go to these assizes and get free briefs from the state for which you are paid, and you appear for various criminals who cannot afford. So that way, you learn to cut your teeth, so to speak, in advocacy, that is, as counsel in court. Of course, during that time, we used to have jury trial, which you don't have anymore. So which means that you have to persuade the jury to be able to see the way you want things seen. The law is given direction by the judge, the counsel will deal with the fact of the jury. So that way, people tend to notice you, and eventually they will brief you, or other way which show exposure to be able to join proper chambers. Now, of course, there are so many lawyers. I don't know, there are sufficient chambers for you to join and to be trained so in chambers, you will sit as a junior lawyer. You hardly spoke. They say juniors not be seen and not heard. So we listen to them and then be able to study the brief and impress upon the senior that you know the case, you have studied the case, and when question time comes, when you discuss it, so that way you need to bring yourself to the attention of those who are senior to you, whether they are proctors or whether they are advocates. The same thing continued soon thereafter as well. Now things have changed a lot after so many years. So people will notice you. Then those days the proctors will give you a small brief to test you. Advocates can, those who appear in Supreme Court, will give you 50 rupees to go and make an application to get their license, the notary licenses extended every year, sort of thing. So try it out, and we'll send you into court to support a motion or something like that. Then they will see that you are good or you know your stuff, and you get noticed, and then the seniors will nominate, I want him, sort of thing, That is how. So building up a good practice means you have to consider yourself lucky to be able to join some good chambers, and there's no shortcut. You have to study your brief very well, and you are not given separate briefs. You have to borrow the brief from the senior. He must trust you enough to give you the brief, and you study it and return the brief. There was only one brief. We never had photocopying machines then. These are carbon typed papers. Very rarely you get more than one brief. The senior has a brief, you borrow it, take it, and weeks before you take it and study it. And without marking anything on that, you make your own notes, and they will note, oh, this boy is hardworking fellow, perhaps give him a chance. So next time a case comes, then they will suggest you. There was years ago, there was a famous queen called Mr. Navaraja, and some parties from the proctor brought some clients from Nigambu over a divorce case. So he told me to come, and they had a conference, and then I had to take. Those days we take notes when the clients come and tell you this is a story with the proctor. If he doesn't, outstation proctor really did not prepare proper brief. Columbus proctor did a good brief. They tell you what the case is all about and witnesses and things like that. So if that is so, you must make it. So at the end of the conference, those days, just an interesting story, anecdote to see how it was in those days. Fees were charged in terms of guineas. I don't know, Daphne, you remember it. Guinea. Guinea is 10 rupees 50 cents. So they say, my fee is 10 guineas or 5 guineas or 10 guineas will be 105 rupees. So at the end of the conference, the Nigambu proctor asked me, Sir Navaraja, what his fee was, and then he told me a junior fee, 10 guineas. So he put some money into the envelope and gave me. I was then living alone, not married, top of a garage, even a small room in Schofield Place. So you didn't cook. So you went to, there's a place called Saraswati Lodge. I don't know whether it's still there, and Gold Road. So I thought I have a good dosa feed. To find that I was given only 10 rupees. Not 10 guineas. He took it as 10 rupees and gave me 10 rupees. That is because he suggested my name. He must have been found myself impressive, good fellows is working hard or something like that. Of course, otherwise you must have an elitist child so that you have family help along to your recommended like that. You see, that is the beginning. But to sustain yourself in the profession, you have to work hard. There's no compromise. You can develop a practice. It will take good 10 years those days to be able to stand on your own feet and command a brief by yourself. Those days it was very tough that way because there were few advocates, though not many proctors. And so the proctors are the ones who decided whether they will get a brief or no. So that was a different regime. Now, I don't know, so many children are there. How they do it, I think maybe Farzana knows better. how they manage to come up in the profession. Of course, here now the young lawyers can go and appear in the Supreme Court soon after you have fundamental rights and things like that. So you have a better opportunity to showcase your talent. End of the day, you are basically selling your product yourself to say that this is good, you can rely on that. How do you do that? You have to do that because you know your brief, you know your law, you know to present. So ability to speak advocacy well and clearly so that people understand you is very important, because they don't understand you, what you speak. So speech therapy, the participation in moods and debates like that trains you well to be able to be an, I call them advocate because in court it's advocacy. You are selling a product. You must persuade the judge, whether good, bad, or indifferent, you must persuade the judge to see your way. So you must be able to, like selling is no different to selling a product. So that you must be able to, how can you do that? Because speech is important. To be able to articulate yourself is important. And the fact that you will represent the law correctly. So you must have a reputation, so people will trust you. So the making quick buck, saying anything that comes to your mind to get an order is not going to help you in the long run. So building up a good practice means building up a good, trustworthy reputation. People will respect you, the knowledge of the law, that is very important, and hard work. There's no shortcut to hard work. That briefly, I mean, we can talk a lot about it, but then time constraints, so I will say hard work, dedication, good conduct, integrity, all very important to be able to sustain yourself at the bar. So people will trust you. Main thing is people must trust you. That is important. So they feel happy, safe to handing over private, especially in human relationship cases. That's very important. Trust is very important. People often come sometimes and I say you could have gone to the other lawyer, no, he's better in the field. No, they say you can't trust them. So trust is important. You must build trust and confidence in the others so that they will know they are safe in your hands. After all, they are committing their lives, possessions and their interest in life to your hands. Because what you can do is what they will get. So it's a tremendous responsibility. You know, it may be fun and games wear these gowns and trot about half stop. But at the end of the day, you are handling somebody else's life. And you must remember that at all times. It is, you are serving the public, not yourself. So that's sort of a short, brief statement, Daphne.
Thank you, sir. I'm sure that your advices are very important to our young lawyers. And actually, I was reminded of this when you said about this guinea, the lawyer's guinea thing. I think that is the reason the people used to say lawyers la guinea kana. I think that was the reason. So the next area of our discussion, I would like to say that normally when you pass out from the law school, that you think that, okay, I know very well, I can win a lot of cases and all that. So, but we often know the reality in courtroom practice is something different. So, our next area of discussion is on the art of advocacy, because that topic is very wide. I would like to divide into two and to give chance to Mrs. Jamil for the first part. And Mrs. Jamil, I would like to know about these areas. We often see that academic excellence alone does not guarantee courtroom success. So, how should one prepare effectively for a case? And what are your insights on presenting arguments persuasively and mastering the art of addressing court? Over to you.
I think that's a long question and a complex one. I think Mr. Kanageshwaran would be best able to answer that. But now that you have put me in the corner, I'll try. So yes, getting out of law school even with a first class means nothing in the courthouse. I think that's rule number one. Knowledge is not power in a courthouse in that sense, automatically, right? And therefore, I think there are so many unspoken rules that apply in the courtroom. And the last of it is knowledge. Knowledge is important, but it's not the only thing that will take you far. I think, like, what is more important is to be prepared on the facts of your case. I think that is very important. The judge always wants to know, particularly in an appellate court, not like in a trial court where you lead the witness and you have to, he will take you through the story. I think if I were to answer this from the point of view of an appellate court practice, I think preparation and knowing the facts of your case as much as the opponent knows his own case is key. I think you should know the case of the other side as best as the counsel for the other side knows his case, if not better. Knowing the law is important, but I think looking for the relevant part of the law is more important. Knowing procedure also helps to be able to navigate quickly and try and show the judge what best we can do to get a result in court. And I think most judges do not have time for a long lecture. It appears that as we go on in this profession, judges have less and less time to listen to you because of the volume of cases. So they want us to quickly get to the relief you're seeking from court, navigate them through your facts as fast as you can, take them to the relief you're asking them to give you, drop the legal jargon. Sometimes you have to listen more than you want to speak, and focus on what you want as a result. It is very hard sometimes to push away facts that you think are important, but you have to understand, I think, that the courthouse is not an exam hall, and identifying theoretical problems may not help, because the judge will look towards you to help him move towards a practical resolution that is couched in the law. And I think that is helpful. Of course, developing and having skills never hurts. It never hurts. And I think navigating that is, I think everything comes back to preparation and integrity in the process. Preparation and integrity in presenting what you're presenting as best as you can. Knowing what the other side is going to say, but also defending your position. So in the courtroom, there are some judges who are interested in an intellectual aspect of the case. Some judges will want you to give them precedent, case law, judicial precedent, because some judges are comfortable with that. Some judges are not interested in any other judicial precedent. They will want you to give them the best version of your facts and then take them through the law that the statutory provisions or the theoretical provisions that you want them to walk through you with. So I think that doing that is important, because moving from a law school, law graduate, or newly passed out theoretical graduate, that type of knowledge is not necessarily the criteria that takes you through to a successful decision. So I think it is more important to be concise and precise in what you want the judge to know, and picking and leaving out some of the stuff that may not be relevant, even though you may have academic knowledge on it. I remember walking into court many years ago, and I crossed Mr. Kanageshwaran, I crossed Sir on the corridor, and I had a whole lot of textbooks in my hand. And he looked at me and stopped me. I used to chat to Sir very often. I was also opposed to him, and it was a nightmare to be opposed to him also. And but I used to watch how beautifully he was the most charming person you could see in the courthouse. He was the most charming senior in the courthouse, without a doubt. And he one day asked me, "What are these big books you're carrying?" And I said, "So this is this and that." "Oh, they will have no time for any of this. Just leave them at home. Judge will have no time for any of this." I remember that so well. I don't know, sir, whether you remember this. I was carrying these big textbooks with me, because I would in between read, like if I had to sit in court till somebody else's case was taken up, I would just flip through a textbook just out of interest. And I remember him telling me, don't bother with this. You won't have the time to say all of this. So I think it is more important, and I think that is true. It is more important to know your facts very well and know the relevant law, point out, and also I think own up to mistakes. If you miss a point, own it up. If you have a bad point, own it up and try to navigate. Yes, try to persuade the judge that that bad point on your side is not as bad as the judge might think. But I think it's safer. It's a better insurance to upfront show what our weaknesses are in the case and then say, despite these weaknesses, these other points are in my favor. So can you consider those? Thank you.
And at the same topic, I would like to ask from Dr. Kanakishwaran. So you said that how to build the confidentiality. Now, I would like to you to advise the audience how would you maintain the confidentiality in the courtroom, and also what strategies can be adopted when you're faced with a weak or challenging case, and we know that although we get ready for a very nice argument or a long submission, you get interrupted by the judges and also the opposing counsel. How do you survive in such a circumstances, such an environment? And then when the judge is not on your side, you feel that judge is not on your side, and how do you tactically adjust your advocacy while maintaining the professionalism? I think a long question, but anyway,
Long
I'm sure that
question.
you are an expert on that to give
No.
your best advice.
How to do all that is a lifetime's experience. But there are some basic things that you must remember. The advocacy, I'll call it advocacy, whether in the original court is different to the appellate court. But one takeaway from what Farzana said is this, that first thing any lawyer must know is to understand the judge before whom you are going to appear, whether it's in the original court, appellate court, or Supreme Court, or wherever. Because end of the day, they are human beings, they judge according to their prejudices, their likes and dislikes. So you must understand the judge, because you are selling your product to somebody. Somebody may like it, others may not like it. Then how do you approach them? How do you see that they are willing to listen to you? The main thing is to see that they are listening to you, good or bad case. You must make them listen to you. But you should know the basics of your law at all times, because good case, bad case depends on so many factors. Because you might have a good case, you have a bad witness. He'll let you down because that fellow, is not a smart guy. You might have a bad case, but you have a smart witness who will navigate against a cross-examination. So if your case is weak, you need to concentrate on what are the basic essentials of the law that requires to be presented in your case to achieve what you want. At the end of the day, facts are given, but you must apply the facts to the law or the law to the facts. So whatever the facts are, what does the law expect you to establish in proving your case? The balance of probabilities or beyond reasonable doubt. So the question of law that we have to prove will in large measure drive the approach you take to the case, good or bad case. If it is now sometimes the other thing is cross-examination can very often make good cases bad, because if you catch the opponent on the wrong foot, then your case strengthens, though it starts off as a bad case. Now, I had a very good experience of that long years ago, where we had a foreign witness. We had a bad case for a bank. We had a foreign witness on the other side. And we were able to, to make the story short, I was able to get the fellow to admit to some position that the plaintiff said it was he had no evidence to offer that. But, it depends, as Farzana says, being charming also helps, because you can persuade the people to eat out of your hand. Shouting at witnesses and saying, I put it, you are a rogue, you're that doesn't help anybody. It upsets the people, it upsets the witness. It's not bad, it's very bad in your mouth, but the judge may not like it. Because you can always Good case, bad case, you have to be respectful of all the witnesses. No harm cross-examining them. You don't need to be shouting and things like that. That is because you create then an atmosphere of fairness. The court, people also like to be fair. You can't always be fair, but then you don't want to bulldoze people. You might find it interesting. I think criminal law perhaps that helps, but not in the civil law. Civil law is civil. Criminal lawyer, perhaps in the criminal court, you have to shout at them or whatever it is to get your. So basically, you must know your facts. You must understand your judge. Long years ago, you heard of Mr. Nadesan, Queen's Counsel. He was retained in a commercial law case, in a company law case. You remember Justice A.L.M. Fernando was a district judge who used to sit in the civil court, the district court. We called it court number 5, which was a commercial court, all the company law cases. So Mr. Nadesan hasn't been practicing very, very long time. Then I was retained as junior, and because we were doing this for a case for a friend of his, so they wanted him. So he hasn't been to Halsa for a long time. It was late in his life. So he called me, he asked me, who is this judge in this court number 5? I said, Mr. A.L.M. Fernando. I want to go and see him. I want to watch him. So 1 week before the date of the trial, he came, I took him to court number 5 in the district court, and he sat there whole morning from 9 till 12 and watched how he performed. Understand the judge. He told me, always understand the judge. Know your law, but you must understand your judge. I don't know very which judge is listening, but that is important. Because you know your idiosyncrasy, so you have to navigate. As Parsana says, navigation means bad current, strong current, wind, bad wind, not enough wind, all those will come from the bench. Easy to navigate with the counsel on the other side because you know the guy, but not the judge, you see, because when up here, you are going for. So he came, and the counsel on the opposite side, Mr. Sam Kadir Gamar. So he has a habit of bringing a whole lot of books, and he make his presentation. This was an injunction he wanted. He has a habit of making a presentation, must go out the courtroom to have a cigarette. So during that time, he finished his submission, and Mr. Nadesan got up and propounded objection to the case. And before Sam could come back, he judge held with us because he said he studied that. Then he told me, this is important, study this. So that there are so many things that you need to know, because I found this to be true. And later on, as I carried on with my practice, even now I tell my students, my junior, study the judge. Before whom does this come? So you know what, for example, you know what I am saying. In the Supreme Court, you know what you will get before whom you go, whatever the law is. That's the difference. So if you are prepared, you know how to handle him. You see, sometimes you win, sometimes you don't, but that's not in your hands actually. So what you as counsel, you must remember, you must do your best. Know your case, because you don't decide, somebody else decides. So if you want somebody else to decide, you are trying to get them to your side and to understand that you can penetrate their shield. So which means you can't do it by cheating or by being smart. You have to be, they must know you are genuine and you have a sympathetic case. Another case, what depends on the judge's understanding. I'm giving this example so you will understand what I mean. Long years ago, there was a case, servitude, right of cartway. So the Jaffna came, my father is in Jaffna, an appeal came, Mr. Thiagalayam was my senior. It was you might think it's stupid because you said diem minimis non curat lex. Small law doesn't bother with little trifles. This was a case where agriculturist had a right of way to his land inside from the road, and the pathway was about 8 feet. But he takes his cart through that after the harvesting. They load the cart with paddy, so it bulges out. So that so you need all that width in the pathway to take the cart loaded with hay in a big. So this gentleman who had no right of opening into the pathway built a gate. 6 inches of it was jutting into the lane. 6 inches, just 6 inches of that pillar of the gate. And this fellow couldn't take his cart. Jaffna, they like to think, you go into court. So they brought an action that he is obstructing his right of way, his land, but is a servitude, the case of servitude. Then Jaffna district judge dismissed the case. He said, no, non curate lex. You see, de minimis, non curate. All the trifling thing, but 6 inches, what is this? So when he came to the Supreme Court, Mr. Tyagalikan told me, a lot depends on who the judge is. A judge who has lived in the village will understand half an inch or 1 inch, the cartway right must be preserved. You must, if you are living you don't take empty buses, you take buses loaded. So that, all that. So it has happened. It came before Mr. Barnes Rathwat, Srima's brother. So he told me, we are safe. Those are the only one judge used to hear the Supreme Court, not 2, 3 judges. He said, we are safe because Barnes will understand this. He's a rural background. So like that, so, and happened, we won. We won the case on simply they argued on the other side. Mr. Harry Jayawardena, he said, they minimis non-curate lection, that and this is meaningless, what can you, blah, blah, blah. No, he said, no, if he can't take his cart in, what is the point of right of way? A servitude. Servitude is meant to serve you. So a lot depends on the judge. So no matter how great you are, he is the one who decides. So understanding the judge is important. Presenting, and judges must have confidence that you won't mislead them. So that takes a long time to build the reputation. That is because you must be careful not to misrepresent the law, even if it is your advantage to say this is the law, this is not the law. Because very often I find that the younger judges who come, there are areas which are specialized areas, So you need to be able, sorry to say this, you need to be able to educate them on the law as well. Sometimes if they don't know the law, if you have a criminal man who has practiced, come to the Commercial High Court, then all the nuances of oppression, mismanagement, or intellectual property, unless you have been trained and lectured, it's going to be difficult. So you need to be able to know your basics to explain the case. That is because you will know these gentlemen may not know these things. Recently I can give you instances, but I don't want to. Time is there. So the important thing is you must understand your judge. You must see that you make the best foot forward. You must know your facts. Do not misrepresent, and be courteous and be respectful to others, because respect will beget respect. And that is important. That is code of conduct and etiquette. They have a rules there. Fundamentally, that's what it means. So that is some a lot more, but then you can go on educating. But these are little things. Basics, if you remember, you will build on it. Those days, I must say this, Daphne, when we were young lawyers, we didn't have computers and printing and that and this, so that there were no written submissions. All oral. I studied my writ law listening to Mr. H.L.D. Silva in court. You know H.L.D. Silva, no? We used to have that A4 size monitor Excel book, the big ones, the folio that government department use. We take that, sit in court and listen and take notes. I say it's cite authority. They'll read the authority. Judges will say talk, 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 and the peon will bring the authority. They sit together and read it, and cases go day by day. Not one day today and then 1 month later or 1 year later, other day. No, day by day. And you learn listening to counsel, President's Council, those Queen's Council, address court on the law. You learn it all. But now the young children don't have that opportunity, which is a shame, because everything is written submissions. You don't hear advocacy anymore, not in the original court, or even the Supreme Court or Court of Appeal. Everything's a written submission. Before you start a case, they want written submissions. After the case is over, they want written submissions. You don't actually hear. So what I do is, when some cases are taken up, go down, I sit the juniors and tell them what case was all about. The poor thing, they come behind you and learn nothing, no? Taken up, no time, went down. So I tell them, no, this was a case, make and go study it. Next time, tell me what's going to happen. That, because that is trying to substitute what you would teach them in presenting a case orally. So the juniors, I don't think anybody comes and takes notes anymore. I don't think, because what do they hear? They don't hear, they're shouting and all kinds of things, So I am so sorry that the present system in many ways doesn't assist young attorneys for proper training, and the webinars like this will help. So they will know something. Thank you.
Yeah, thank you, sir. I think now the audience got a very good advices on that, and I know that being a good advocate, now you gave lot of advices on that, is all not enough in that, because we are members of a profession. So there are other lawyers as well, and also there is a thing called professional ethics, and I think Mrs. Jamil is a strong believer of this, maintaining this professional etiquette. And also, I would like to pose this question to Mrs. Jamil. How do you uphold, now what is the advice or the insights that you give to the young lawyers? How to uphold the ethical standards and traditions of the bar amidst modern challenges? And many young lawyers, we can see that although they start their courtroom practice, court practice, they don't survive there. In a short period, they leave the court practice and go. So how do you advise them to remain in steadfast and active court practice? There are two aspects of the questions. Over to you, Mrs. Jamil.
Yes, Daphne, your question is ethics plus conventions,
That is true. Yeah.
right? So ethics is governed by the Supreme Court Conduct of Etiquette for Attorneys at Law, the rules, the 1988 rules, as well as the evidence ordinance. So that is where professional ethics is governed. That is through that it is governed. Conventions is probably, we could say, embedded in those rules in some way. It has found its way into those rules. But there are other conventions that are unwritten. Of course, they're not really in those rules. Those conventions have not been subsumed into the rules. But I believe we in the legal profession love to maintain, personally, I do. I think the conventions of the legal profession as a practitioner, as a litigator, is a very different set of conventions. If you're a courtroom lawyer and if you're a boardroom lawyer, you deal in two different worlds. They're two different worlds. If you're a boardroom lawyer, the conventions you follow will be vastly different from if you're a courtroom lawyer. So let me start by looking at the conventions rather than the rules, than the ethical rules. And I think for me, what I would like to emphasize is respect for hierarchy. Respect, and more respect. I think what we can learn by watching and listening to those who came before us, who know better than us, is vastly more valuable than any book you might read. What I gathered out of listening to Mr. Kanageshwaran in the last 10 minutes, I couldn't have quite found it like that, but the way it was articulated and the little examples that were given to show what it really is to learn in the legal profession, subsumed in those answers of Mr. Kanageshwaran's is what is called respect for convention, for the older person, for the more senior person, and to wait your turn. You learn and prove yourself, first of all. You must know to stay the course. You can't try to jump. There are no shortcuts. There is no brilliance that can take you to the top. There is no extraordinary knowledge that can take you to the top, because knowledge and experience are not the same. To me, experience, I think, is more valuable than knowledge, because actually that has more value. Knowledge is good, because knowledge you have to keep updating, but experience is something else. So for me, I think keeping how you can manage to uphold, how we will uphold the traditions and conventions of this profession and keep this profession as a respected and respectable profession is first to behave in a respectful manner, whether it is to your senior or to a person junior to you, and not to presume that you know everything. I think that convention is important to keep the dignity and decorum of the courtroom and the relationship. I think it is very important. And I don't think that sound can ever substitute for knowledge, or sound can never substitute for ability. I don't think they're one and the same. Some people do think that by sound you can do that. I don't think so. So respect for the judge, first of all. Respect for your opposing counsel, whether he's senior to you or junior to you. Keeping the dignity and decorum of the courtroom. How you dress to court, in court, how you sit, how you stand, whether you expose a part of your physical body which you should not expose, whether you're properly clad in court attire, whether you draw undue attention to yourself or to your clothes or to anything other than your submissions. And I think being punctual is important. Yes, we sometimes get late, but being punctual is important. And if you can't be punctual, letting the other side know that you can't be punctual is also important. Being diligent in what is given to you, I think, is one thing, one way of upholding our ethics. Of course, all of this is subsumed in the Supreme Court rules, the Code of Conduct for lawyers. But I think personally for me, on a day-to-day basis, if I were to look at it, I think maintaining that dignity and decorum with the judge, with the opposing counsel, with your client also, more importantly with your client, who is the person on whose behalf you go to court, and keeping that professional relationship with your client, not to get personally engaged, not to get personally involved in the issue, but to always look at the legal argument for the client, but not to get personally engaged. So it's a whole lot of, it's like a jigsaw and everything must fit. Avoiding conflict of interest between some of your personal views and that of the client or on the other side. So I think those are some of the criteria which I think remain important for us to sustain this profession in a manner that makes the rest of the world look to us as a respectable profession, because whether we like it or not, it is the lawyers who play a huge role in how the entire structure of a country operates, whether it's the creation of law, enactment of law, the implementation of the law, or the interpretation of the law. Lawyers play a big role. So I think upholding the ethics and conventions is important. And I feel that you lose nothing by respecting those above you, respecting those who went before you, who arrived here before you, and waiting your turn, staying the course, not trying to take shortcuts, I think is important. And as to whether how you will ask juniors to, how you would persuade them to stay, well, it is a challenge, because unlike several years ago, like what Mr. Kanageshwaran said, they had one brief and everybody had to study that. I was surprised to know that. And you couldn't mark on it. So obviously, if you had only one book and we were all sharing one book, the level of concentration that was needed, the level of discipline that was needed to study that in a limited time and give it back to the senior, I think that is why the lawyers of that era are way superior to the lawyers of our era, because they had to learn the facts, the law, everything on their own, remember it and manage it. We have the luxury of several copies, immediately at the click of a button getting information, and thereby dulling our senses and dulling your ability to think. And I think that doesn't help us at all. And that's probably why people don't think that you need to stay around your senior and learn from him or her and learn they think that knowledge can come easy. Yes, I can at the click of a button get knowledge. But I go back to saying that the click of knowledge at the click of a button can never be equated to the experience, the invaluable experience that comes from watching seniors in court, from watching amazing advocates navigate their way through the most difficult of cases. So if I were to go back looking at my personal experience, I remember in 1992, I was prosecuting in Kalutara, and I used to be able to come back to the Aegis department on one particular day of the week. And I remember going to DC #1 to watch a famous trial of the time. One was, it was the trial of Professor Priyani D'Souza. And I was very interested in that because the person, the plaintiff, was my senior in the department. And so on the death of the child, the claim for negligence was filed, professional negligence. And when I was watching Mr. Romesh De Silva leading that evidence and breaking down witnesses, it was like watching a magnified movie. And what, I mean, it was such a learning experience to see how you must deal with a witness. I mean, it was brilliant courtroom tactics. And there was another famous lawyer on the other side. And so that's one case that I remember very well as in a trial court, watching and learning how how you can manage a witness. And like Mr. Kanageshwaran told us a few minutes ago, you can have a very good witness, very knowledgeable, who can let you down. And you can have a good case and a bad witness, or you can have a bad case and a good witness. And it is sitting through that experience, watching this kind of brilliant trial advocacy that really brings out what the example that Mr. Kanageshwaran gave. I was thinking back at that. I don't know whether who was good or who was bad, but the way the facts was navigated to achieve a particular point of law, that was what was fascinating. So I believe that conventions, if you go back to your question, how do you keep people in this profession? I think, yes, watching the seniors, watching what they've done, but as Mr. Kanageshwaran just said, now we don't get a chance to really listen to that kind of arguments, and because there's no time to do that. There's such a volume of litigation. Judges do not have the luxury of allowing you to, wax eloquent, if I may say so, on a really brilliant point of law. So that's the difference. But I would say, go back to the convention to answer your question. I think being respectful, being ethically mindful, being honest, and doing and having integrity in what you do. Like integrity, as you know, is doing something even if nobody else is watching, doing the correct thing. So I feel those are the kind of criteria or the points that I would like to leave for the younger group. Thank you.
Thank you, Mr. Jamil. I know those are the golden principles that you have adapted through your long practice. And you know that we saw how you can become a successful advocate. Now, winning, I mean, after being a good advocate, when you win a case, I know that the lawyers are very happy, then they are very jubilant. But we can see most of the time we come to settlements in the courthouse. I think it's most of the time win-win situation for both parties. So I would like to pose this question to Dr. Kanageshwaran about this settlement dynamics in courtroom. What are the advantages of settling cases rather than pursuing prolonged litigation? And could you share your real life examples where settlement proved to be the wiser path?
Yes, that is a very important question because I'm sorry to quote old seniors because I learned a lot from them. Mr. Tyagalingam Queen's Counsel used to tell me, it's better to have a bad settlement than costly litigation. Because time and money is spent a lot in long litigation. Settlement requires a certain frame of mind on both sides, which includes not only the client, the lawyers also. There are some lawyers who will never settle for anything. But you find that settlement requires the meeting of the minds to understand that it is better this way, addressing the benefit of both sides to settle the case. So how do you settle? Which means when people come angrily against each other and the case runs for some time, sometimes people are tired with the length of time taken by the case, and then they agree to settle. So settlement, trying to navigate the settlement, you must be able to, if you are a plaintiff, you must be able to see the other side case and see what is the best way forward on which there can be a compromise. That is a difficult, because if you are the type of counsel who say no settlement, you must fight it to the last, then you will never work it. It doesn't, you might be able to carry on with the litigation and earn more money, but it doesn't help the litigants. So settlement requires a kind of empathy that you must have. Both sides have a case. How best can we adjust this? Now, very often, those who have been involved in arbitration often find that the approach to settlement requires a certain frame of mind, because you are looking at the best interests of both parties. It's not easy. You are retained by one party to raise this case, but when you look at settlement, you are looking at the other side also. You see the good and bad points of the other side and try to find a common via media where they can meet across it. Sometimes you find settlement is effected because the reason why a case has been filed is for some reason other than legal rights. I had a case long years ago where there was a foreigner who wanted an action filed. I did not know that initially, because he had been slighted by the other guy. A local had slighted him and he wanted to teach him a lesson, and he could afford it because he lives abroad and rupee was, his foreign currency was worth much more than the rupees. He could afford to spend it. So we were happily paid. But then the real reason was something else. It turned out, and some conversation I had with him, when he comes from abroad, he'll talk to us. One day at a dinner, we had him home for dinner, not home, at some hotel. And he told me, this fellow, he did this, if he hadn't done that, we wouldn't be fighting this case. So, this is where, as Parsana said, you must respect the counsel on the other side. You must always treat him as a colleague worthy of respect. Because he is also holding a brief for somebody else, and he has to argue, he do his best for the other side. That doesn't mean that you must be angry with him or found him to be at fault. No. So this young man on the other side, probably because he respected me, I told him, this is a problem. Will you consider your guy apologizing to this gentleman for what he did? He said, sir, I will put it to him. And so it so happened that he agreed. And then the foreigner, we had them together and he expressed his apology. I'm sorry I did this. And that he withdrew the case. He just withdrew the case. No settlement, that was a settlement. He withdrew the case. He was not after the money. He wanted to make a point that this fellow did this to me. So the cultural backgrounds of clients is very important in question of settlement. You must understand where they come from. Cultural background. There might be ethnic problems, there might be caste problems, there might be religious problems. So if you want to settle, you must go to the core of the dispute. Why did this happen? Did he cheat him or did he promise him or what? So that way, to be able to effect a settlement, it's very difficult unless you understand the other side also. So the empathy is required. Understanding the other side case is involved is essential, so that if you understand that, then you can effect a settlement. Settlements are good because it means parties are happy as they shake their hands and go away. But how do you achieve that? That is where the talent of the lawyer comes in. If we genuinely want, because now many commercial disputes, people don't want to court. They don't even want to go to arbitration. So I suggest, will you look at a settlement? They say, how do you settle, sir? I said, well, this way say, that's what I say. This we can cut, if you are going into litigation, it's going to cost you, and this way you can't guarantee how soon the case will be over. It will go on for years. And judgments sometimes are delivered 3 years later in the highest courts. So how do you, because litigation means you are going to be awarded interest for 3 years over the time when the judgment was not delivered. See, all the things we are weighing into has to be very carefully studied, and the party, you must be able to meet. Many years ago, when we had a whole lot of IP cases in the tea industry, those days, most of the exposed to the Middle East had birds. Some duck facing, 2 ducks facing each other, 2 ducks backside, sideways. So they copy because the graphics attracted the populace where it was being sold. So people start copying. So there was, I don't want to mention the name, the tea exporters, he was my client. And he came and said, this is a nuisance, all the fellows are copying. So we said, why don't you organize a meeting with these fellows at a hotel? At the time, there were a few hotels, but this one talked about 30 years ago, and have a chat with them. So it so happened, the instructing attorney, those were proctors on the other side, they were amenable to these kind of thing, not anymore, I guess. I don't know, the modern children look at these things differently. We sat on the table and worked out a settlement that he will have his word in this direction so that there's no act of confusion. So we can't say there's a violation of my trademark and things like that. So a lot of the trademark those days, we adjusted it after the initial injunction was obtained, restraining them from doing it. So another case where you can explore settlement is when you, in commercial matters, is after the injunction. Once an injunction is granted, then sometimes you find it's not worth carrying on the case for the defendant. So you must offer a fee. The plaintiff must initiate. Why don't we do this? So that can happen, because we had a case which ran for a long time, but in the Supreme Court, I managed to persuade the other side to grant me the injunction because they were also tired. That a lot depends on the counsel. So the counsel must be free to be persuaded to look at a settlement at any time. And that's only fair. After all, of course, if you carry on, you get your fee. But then beyond the point, I don't know whether that's the right approach. So settlement must always be looked at, especially now, because the litigation, time taken, the expenses involved is that people want to pursue litigation. They're very anxious, but they say if you go to him, he won't settle, he want to fight it to the end. So we have the young lawyers, because if you settle, I think I have a feeling that if you see more settlement, more cases will come your way. People will know you are a guy who can be. Now you have alternative resident coming the center stage with mediation and things like that, which is directed towards settlement, amicable settlement. So if the idea of a settlement is very good and should always be explored, I think maybe I'm getting softer in my old age, but now I look at the settlement, if it is possible in commercial cases, because it becomes, it seems to me very unfair to spin this out. But younger people, of course, may not be differently, but just a thought, I leave it that with you. Varsana, what do you think about settlement?
Yes, I
Very
think now
difficult
we
to
have.
settle with Varsana in such cases. But you are in the state.
Is it Vijay Javed? Okay, I think that you have shared your lot of good advices and insights into this topic of navigating your career in the courtroom. As a final remark, I would like both of you to give a brief advice or something like that. What was the great challenge that you faced in this navigation of this court practice, and also what is the message that you can give? I think you have given a lot of advices and messages. As a final remark, what the message that you can give to these young lawyers?
Young lawyers must know nothing comes easy. Hard work, dedication, integrity is very important, so that people will know you are trustworthy, they will they will give you their piece of the work for you to do it. And on your part, to be able to service the clients, you must always be focused on the principal issue. You must know your basic laws. Mr. H.V. Pereira told me once, I was only once his junior in a case, and he told me, if you know your basic principles, this is soon after I came back from England, I was full of English contract law and that and this. He was arguing a matter against Harajay, and I found that the contract law that he was propounding was wrong. So I told HV, sir, I don't think this is the law. What do you think? Then he told me, I agree, young man, know your basic principles of the law, and you will find that some judge somewhere has said the same thing. So that don't clutter your head with judgments. Don't clutter your head with judgment. If you know your basic principle, any judgment has to go on the basic principle. So if you know your basic principle, then you can navigate around. You can distinguish judgment. You can say it cannot, is not applicable. So that's the basic. So study the basic. The other thing I learned from Mr. Tyagalingam is, in any case, you must have a list of the chronology of the events. Because in life, things don't happen haphazardly. There's a system. You come, you go, then you come again, you did that thing. That's a chronology. So if you work the chronology of a case, said we had documents on both sides. You work the chronology, you find that your document will be the defendant document, then the plaintiff document, then you know the story. Out of that, you get a basic picture of what happened between the parties. There you will freeze in your mind the sequence of events. That is basic. So you must know your basics, must know your chronology of facts of the case, so that from that you can develop your argument. And nothing short hard work is the shortest cut to success.
Thank you, sir. Mr. Jamil, you also would like to add something to that?
Thank you, Daphne. I don't think I need to add anything more to what sir has already said. I think that's it. That would be the correct place to stop. It would be the same thing. Yeah.
All right, there we come to the end of the session. And on the plenary sessions, I have one question on the question box that he has asked up to what extent the skills in the art of interpretation would facilitate a lawyer to convince a judge. I think that what he might mean is, now we know that in the courtroom, we interpret the law to suit our case. The same law we are giving in separate interpretation when we are appearing for the defendant, and on the other time to the plaintiff as well. So maybe he's asking on that, what what are the extend the skills of interpreting. I don't
Interpretation
know.
of a law, it's a contextual thing. The law says that this is this. Whether that particular section will apply to a fact situation is another thing. So you must always, when you are seeking to interpret a section, whether in your favor or you must give it the context in which the situation arises. Very often, Farzana knows that in tax cases we have this problem. The story is one. You did not do this service abroad, you did it locally. So the context of the law will tell you which way to argue. You say no, the emphasis may vary, but the basic law remains the same. So it depends on what kind of brief you have, whether plaintiff or defendant. You can, in applying the law, contextually give it different interpretation. Eventually, the court must decide, because any case is not, the law is not the thing, it's the facts of the case. What are the facts? How does the law hit the facts of the case? You don't look at the law and say, these facts are different. No, you must understand that in a commercial relationship, parties have a particular trait. They don't do it to avoid the law. They do it. This is the way you do it. So you must understand the relationship, factual relationship, and see in the context of the law, in the context of the facts of the case, how is the law to be interpreted, So It depends on the facts of the case as to how you want to interpret it in your favor. The law remains the same, meaning that the black letter law is the same. But whether it's applicable in the way you want it, your case is a different. So that's a context.
Okay, I think that those are the only questions that has been given in the question Q&A box. So I think we have come to the end of this session. I think it's a very useful session for everybody. Over to you, Isuri.
Thank you, madam. This brings us to the end of the 5th webinar of the series on professional, personal, and career development titled Navigating Your Career in the Courtroom. I thank our esteemed panelists, Dr. K. Kanagiswaran, President's Counsel, and Ms. Farzana Jamil, President's Counsel, and our moderator, Ms. Daphne Pires Visundara, Senior Attorney at Law, for the fruitful and educational discussion and for dedicating your time to be here with us today, and for sharing your insights, which I believe would be highly beneficial for all our viewers today. I thank the BSF Women Lawyers Professional and Career Development Committee and the BSF Webinars and Legal Symposiums Committee for the dedication and hard work in organizing this insightful webinar. And last but not least, I thank all of you who have joined in for the session today through various platforms and for the interactive discussion that we've had. Thank you, and I hope you all have a very good night.